Hi, I'm Mark Mifflin. I'm a member of the Illinois Association of Defense Trial Counsel Legislative Committee. I'm here to provide you an interim update between the end of the spring session and the beginning of the veto session, which will occur on November 13th, the week of November 13th, and then also the week of November 27th. So at this point, the legislature has gone home at the end of May with all the bills that they acted upon. The governor has acted upon all of the bills which were passed by the General Assembly, including signing some, vetoing others. So we're kind of in no man's land as to those that he signed that may have become law or will become law, and those that he vetoed will come up again. So there's some activity, some final activity to report, and some interim activity to report. The first bill is Senate Bill 2432. This is a bill which eases the formal requirements for summons, particularly whether or not the named defendants have to appear on the face of the summons. This is a result of a line of mortgage foreclosure cases where the mortgage foreclosures and sales were determined to be void because the summons requirements had not been technically complied with, even though in those cases, many of those cases, everybody knew what was happening and everybody admitted that they knew what was happening. So the bill says it's a statement of existing law, but it is intended to correct that problem. But the law has taken effect immediately when the governor signed the bill, and it does ease some of those formal requirements for mortgages. The next bill that the governor acted upon is House Bill 4242. This bill requires 72 hours notice of any severance or settlement agreement regarding local government employees that have been determined to have committed sexual harassment or sexual discrimination. It's intended to prevent confidentiality agreements by local government entities with their employees, and rather put some sunshine on those types of settlement agreements 72 hours in advance so the public will be aware that that is happening. There are several bills, 3 bills specifically, that the governor mandatorily vetoed, which the IDC was following very closely. A couple of them came up at the last minute in the spring session. Senate Bill 904 is one. It's a work comp bill, but it allows the medical providers to specifically sue in court if certain conditions are met, to sue in court to collect their fees, even during the course of the workers' compensation proceeding. And we think this is going to be very problematic if it becomes law, because the issue of, like for example, arising out of it in the course of employment, a causal connection, may not have been decided yet in the work comp proceeding, but it will have to be decided in the court proceeding. Just by way of an example, it's really going to clog up the process and extend the process rather than streamline the process. So we have opposed that bill. The governor did sign it. It did pass with an overwhelming majority, partly because it came up at the last minute and there wasn't really time for the opposition to mobilize. Another bill the same way is Senate Bill 1737. This is an omnibus insurance bill dealing with several different provisions. One is workers' compensation rate regulations and some other substantive provisions, minor substantive provisions in work comp. The other one is short-term health care policies, reinsurance collateral requirements, captive insurance issues, and divestiture by stock insurance companies. The governor mandatorily vetoed the workers' compensation rate information out of that and the health care provisions out of the bill. And again, that bill will likely come up, just like Senate Bill 904, it will likely come up in the veto session for an attempted override. The next bill is Senate Bill 2481. Excuse me, this arises out of some deaths that occurred at the Quincy Veterans Home as a result of Legionnaire's disease. The proponents of the bill came in at the last minute and raised the cap on these cases in the Court of Claims in tort cases from $100,000 to $2 million. It applies broadly across the board. It's not limited to the Quincy Veterans Home cases, but they used those cases as a lever to come in and try to raise that to $2 million across the board. The governor saw that that was kind of a power grab, and he reduced the increase from the $100,000 figure to $300,000 rather than the $2 million. So that will also likely come up in the veto session. whether or not to accept the veto or override the veto. There's several different things could happen with these bills, the 3 bills that he mandatorily vetoed. The legislature could accept the vetoes, which I think is highly unlikely. The legislature could probably attempt to override the vetoes, which is probably what they will do. Or they could do nothing, in which case the bill would die, and they could wait to take it up in January if there is a Democratic, if J.B. Pritzker defeats Governor Rauner in the gubernatorial election in November, which may happen on some of these bills. I think they'll try and override on all of them. And if they fail in the override, I think they'll wait till January. If they succeed in the override, of course, those bills become law right away. And I don't think there's any way that they will accept the governor's overrides rather than let the bill die and try again in January. Now, all of these bills are accessible on the Illinois Defense Council website, so I urge you to look there if you have any questions, or give the Legislative Committee a call, or contact the IDC, and the Legislative Committee can get back in touch with you to tell you where we are or what's going on in the legislature. Like I say, the next activity we expect will begin in the veto session on November 13th, which will be after the November election. So we'll go from there, and we'll give you a report after the veto session at the end of November to bring you up to date on all these all of these bills. Thank you very much.